you are the right person to talk to us about the legal aspects of AI. It's a great pleasure to have you. And as we communicated, we have, as I said before, we have few researchers, academics on the call. I even have a head of law school with us, which is really pleasure to have.
Oh,
Caroline is here.
fantastic.
Yeah, from Hull, and as I said, also students from MSc Artificial Intelligence program, which is our online program. We have a program lead, Ramiz, as well here. As I said, we'll record this to share it with the students later on, but we will definitely check with you before we publish your talk anywhere else, Ivo. And yeah, so floor is yours, Ivo, and please, yeah, thank you. And I think you have a talk or a presentation, roughly 30 minutes, and then
Yes.
we'll take questions at the end.
All
Um,
right.
all right, floor is yours. Thank you.
Brilliant. So I don't know if you can see slides. Maybe not. No, there was a problem. Just a moment. If not, I'm just going to share screen. Yeah, I think that would be the easiest. All right. So first of all, hello everyone. Actually super excited to be here with you today. So my name is Ivo. Thank you, Dhaval, for the lovely introduction. I think you said more than I could. I mean, I'm actually doing a lot of things. One of which is obviously now dealing with things like the AI Act and what's in store for everyone out of this instrument. I have lots of affiliations. Today I'm speaking as part of the interdisciplinary research team of the Gate Institute in Sofia, where I'm leading our newly established policy lab, where we aim to study problems of artificial intelligence from very many different angles and data governance. Of course, with my team of which includes lawyers, people with policy analysis, political science, and of course computer scientists. So it's a very diverse group. So when Dhaval invited me to give this talk to you, I know I only have 30 minutes. So in 30 minutes, you can hardly even explain why the Act exists or why it's important that we understand what it says. But since I mean, many of you are part of the Responsible AI group at University of Hull, I thought, okay, perhaps I should maybe take this angle to the talk of where do we find responsible AI in the AI Act, because I have this feeling that the idea of responsible AI was somewhat lost in the discussion. So, back in 2019, when the high-level expert group of the European Commission announced its guidelines on how to ensure trustworthiness of AI systems, there was a lot of talk about responsible AI. And then all of a sudden, when legislation started to take shape, the first proposal was tabled in 2022. And then with the discussion, somehow the idea of responsible AI seemed to have, I don't know, I would say maybe subsided, at least taken the back seat. Now, that's not necessarily the case. There's a lot about responsible AI in the Act, but it's not phrased as such. So what I'm going to do is focus mostly on the definition, so we understand what it is we are talking about, what is in scope, what is not in scope, and then in roughly 25 minutes or so, I will just open the floor for questions, because I think that will be most interesting to you to actually ask questions and have this discussion of what the Act is about and how it implicates you. So let's start with the good news. And the good news is that this regulation does not apply to systems or models, including the output, when they are specifically developed and put into service for the sole purpose of scientific research and development. So what does that mean? It means that you and your European counterpart in the EU, as researchers, actually have no obligations on the Act as such, so long as what you develop and put into service is created for the sole purpose of scientific research and development. As you can see here, research and development is qualified. So we say scientific, not just any type of research and development, because obviously we also have industrial research and development. And I would argue, perhaps not to the benefit of many companies out there, that industrial research and development is actually most probably not covered by this provision. Of course, you could always twist the interpretation, but I think it's quite clear that it is indeed scientific endeavors that are covered by, that are actually not covered by the AI Act. And then secondly, the regulation also does not apply to systems released under free and open source licenses. Now, you should probably know, or maybe you know already, that there is a definition already that was adopted maybe last month of the open source initiative. You know, open source initiative is a steward of the open source definition. And in 2023, they kicked off a discussion, global debate on whether we need a new definition of open source specifically for AI. There was an almost uniform consensus that there was such a need for this definition. I'm pleased to say that I was part of actually crafting this definition, which to some of you may seem convoluted, and some of you, especially the open source advocates amongst you, and I am myself an open source advocate, might find troublesome. But the idea is that we keep, in this definition, we keep the idea of the 4 freedoms to use, study, modify, and share, but we do not refer to AI as a software, but rather as a system. So the idea of the system is critical in understanding the object of open source AI licenses. And by system, the definition understands a fully functional structure and its discrete structural elements, as you can see here. Now, in open source licenses, we always talk about the preferred form of modifications, because to be able to exercise these 4 freedoms of using, studying, modifying, and sharing the system, you must be able to work with its building blocks, so to say. And in this case, there was quite a controversy around the types of preferred forms of modification that we could have in an AI system, which is quite different to the traditional way we understand software as a human programming activity. And in this sense, we came with the idea of having, so as to have a preferred form of modification, you must at least have access to the information about the data sets, you must have access to the code, and you must have access to the parameters of the model. Now, the problem, as you can probably guess in this definition, is the data information requirement, which says that you must have sufficiently detailed information about the data used to train the system so that a skilled person can build a substantially equivalent system. The idea was the following. We did not want to put a mandatory data disclosure requirement, because in many cases, systems that would otherwise qualify as open source would not qualify if we ask their providers to also disclose in full the training data sets. These training data might be subject, for example, to different regulatory requirements. You might have personal data in the data sets that you will have trouble, fully disclosing. So that was a compromise. Many people in the open source community are actually not happy with this idea of data information and the fact that we don't actually ask companies and providers more generally of AI systems to disclose the full training data sets. Then, of course, nothing prevents you from disclosing in full the data sets, of course. But the main objection was that this would probably lead to open source AI systems that are not truly open source, because without having access to the training data, you cannot really claim anything to be open source. I have my own comments and responses to that, but this is as state-of-the-art as it is today. So just know, for reference, there is now a definition of open source AI. So whatever the AI Act means when it says free and open source licenses will be judged against this definition. So you might, for example, release under the Apache 2.0 or MIT license or GPL even, but then you would need to assess against the criteria set out in this definition. So with this in mind, you now know what the AI Act does not apply to, but to the categories of systems and models that it applies in almost in full. So what are the principles of the AI Act? It's important to understand that in essence, the AI Act is product safety legislation. So think of the legislation that applies to a smartphone, for instance. Putting it into service or placing it into the market means compliance with certain safety, primarily safety requirements, which means, simply put, it would not explode in your hands once you turn it on. So literally the same type of thinking, of regulatory thinking, applies to AI systems. Whether that's good or bad, I'm not judging now. But these are things as they stand currently. So primarily, this product safety legislation is concerned with risk to health, safety, and now for the first time, I would say in a product safety legislation, we also import these fundamental rights risks, which are a very broad category, and they originally come from, for example, the GDPR, where we have quite a bit of discussion about risks to fundamental rights created through the processing of personal data. Then the AI Act addresses systems and risks that may be generated by the AI system, focusing primarily on the high-risk category of systems. So remember this: the AI Act does not aim to cover any sort of AI system out there. It is primarily concerned with those AI systems that create a high risk in environments where deployment of such systems and scenarios where deployments of such systems would actually create significant risks. Think of, for example, proctoring systems where you monitor the biometric traits of a person, what they're doing while they're taking the exam, and so on, or in a workplace environment where you might have employees that are continuously being monitored by their employer, what they're doing, how they react to messages, for instance, how their performance is impacted by receiving an email on Monday morning saying something urgent by end of business today, and so on and so forth. So these type, also, of course, in law enforcement, biometric identification and so on. But these are literally the types of, I would say, common sense to most people, scenarios where you would think, okay, this is probably high risk. And then the fact that this legislation is risk-based means that you need to continuously, it's very much like what we have in the GDPR, you must continuously assess risk and regulate, adjust your compliance, your measures, mitigation measures, according to the risk. But the risk we are talking about, not just pre-deployment, but also post-market deployment monitoring. So really throughout the life cycle, until after you have decommissioned the AI system, it is no longer in use. So this is a continuous compliance expectation, I would say. And then particularly the rules applicable to AI systems and so-called general purpose AI models. So think of general purpose AI models as foundation models. So the concept that was developed by our colleagues at Stanford back in 2020, if I'm not mistaken, in the famous report of Bomasani and others. This concept of foundation models is really what the AI Act is talking about when it says general purpose AI models. And then finally, these rules really, specifically for models, aim to apply throughout the entire supply chain. So the AI Act tries to capture all actors, all the way down from the providers of data sets to the actual deployers of AI systems in an operational environment. So you as a user of an AI system. Now, you will find in the AI Act references still to responsible innovation and responsible AI that I mentioned. So actually all of the principles of the high-level expert group on AI are reproduced as ethical principles of AI. So they are not actually mandatory obligations, but they are rather a framework that should guide providers of AI systems when developing these systems as to what they should take into account. And now, of course, we have many quantitative approaches towards these requirements. For example, for fairness, for interpretability, we have frameworks, we have tools, and all of these tools should actually be used and implemented into operational AI systems. So, as I said, the purpose high-level protection of health, safety, fundamental rights against the harmful effects of an AI systems that are deployed in the EU. So you might wonder, why should I care if I'm based in the UK? Well, so long as you target in any way a system that is deployed at European citizens, you would be caught by the regulatory scope of the AI Act. So in this sense, we apply this effects-based extraterritorial application of the AI Act, very similar to what we have in the GDPR. So long as there is an effect that is produced in the EU, we will try to capture the entity that is producing this effect. And then, like I said, this whole regulation follows product legislation logic, so focusing on the trustworthiness of the AI system, the requirement that only safe and compliant products find their way into the market. And all of these product safety requirements are actually part of something that we call in the EU the new legislative framework. So this is a framework for essentially creating safety requirements for devices and other sorts of products that are placed on the market. And they apply particularly to data protection, consumer protection, fundamental rights, employment, protection of workers, and product safety. So all of these sort of fields, there are 26 in total, they are captured under this umbrella term of new legislative framework. And then, here you can see, just for reference, the building blocks of this new legislative framework, the 26 legal acts that we have in the EU, including machinery regulation, medical device regulation, toy safety, everything that comes with a safety concern in mind would be in that list. So why am I saying this? Because if you actually want to understand the logic behind the AI Act, you need to go back to this framework that we call new legislative framework. And then the key elements, again, public protection objectives, basic safety characteristics, ensuring that there is ongoing conformity. This CE marking that you can see on the slide, it's what we literally have on all our devices. It's precisely that. You need to also have AI systems that come with this CE marking, which attests the conformity of the system with the requirements of the new legislative framework. And then product quality chain, this comes with all these supply chain requirements that I mentioned. Now, I missed that second element, which is the essential requirements. So these will be operationalized through technical standards. Now, these technical standards are not yet in place. They are yet to be adopted, refined, discussed, and so on. So I would urge you to keep an eye on this activity, which is going to be stewarded by the European Commission, and participate actively in the process, because providers of AI systems will be able to attain compliance with the AI Act through conformity according to these technical standards that are going to be deployed. So this will actually facilitate quite a bit the process, and it will, in the long run, probably become as routine as placing a new smartphone on the market. Now, because it is a risk-based regulation, the AI Act actually comes with a categorization of risk. And I already mentioned that it is mostly concerned with this category that you see at the top, almost at the top of the pyramid, high risk. But before we get to the high risk, we, of course, have the minimal risk, which is at the base of the pyramid. Why is it at the base of the pyramid? Because the European Commission assumed, when the AI Act was adopted, that most AI systems, such as, for instance, AI-enabled recommender systems or spam filters or any sort of technology that we used to call data analytics back in the day, so the majority of it at least, that works sort of in the background, we don't even notice it, would probably fit into this category of minimal risk. So the assumption is that most systems on the market are actually minimal risk systems. Minimal risk systems are actually not covered at all by the AI Act. So long as you do not fit in any of the other categories, you're actually free to do whatever you want. With your AI systems, of course, companies can voluntarily adopt additional codes of conduct, maybe, but those that are not obliged to will probably not do anything. And then the second category is the so-called specific transparency risk category. So these are AI systems like chatbots, they are required to very clearly disclose to users that they're interacting with the machine. And this also covers certain AI-generated content. Think of deepfakes, for example, which must be labeled as such. And users need to be informed when, for example, biometric categorization of emotion recognition systems are being used. Also, providers will have to design systems in a way that synthetic audio, video, text, and images content is marked in a machine-readable format and detectable as artificially generated and manipulated. So that's why we call them specific transparency risk, because you basically need to tell your users, okay, these are the capabilities of this system, so we should let you know that you are in fact interacting with an AI system. And then, of course, the high-risk AI system, the category that is of primary concern to the AI Act. These are systems. These systems must comply with a very strict set of requirements, which include risk mitigation systems, high quality of data sets, logging of activity, detailed documentation, clear user information, human oversight, robustness, cybersecurity, and accuracy measures. Also, this is where the idea of regulatory sandboxes as testing environments kicks in. They are primarily aimed at this category of high risk, so that on the one hand, companies developing these systems can get sort of regulatory approval even in advance, and then regulators can also learn a bit more about what these systems are doing and the actual risks that they present. And then finally, at the top of the pyramid, you would see it's not even mentioned, it's not named here, but it's called essentially unacceptable risk or otherwise prohibited practices. So in the AI Act, you will see it is called prohibited practices. These are essentially AI systems considered a clear threat to the fundamental rights of people, and they are banned. What are the examples of such systems? Well, applications that manipulate human behavior to circumvent users' free will, such as toys using voice assistants, encouraging dangerous behaviors of minors, for example, or systems that allow social scoring by governments and companies, or applications of predictive policing, and also some certain uses of biometric systems like for emotion recognition when used at the workplace, and also some systems for categorizing people or real-time remote biometric identification for law enforcement purposes. There are some exceptions to this for law enforcement, as you would probably imagine, but for the better part, I would say these are indeed excluded, and to me, actually for good reason. Of course, most of these practices are not practices that occur in the EU, but are practices that we know occur in other parts of the world, and we sort of take an approach that says categorically, no, this is unacceptable and therefore prohibited. So now I did not mention, there are certain requirements besides the requirements for systems, there are also requirements for general purpose AI models. I will discuss the difference in a moment. I understand that you might be a bit confused as to why do we use the two and what is the relationship between them. But there are also requirements concerning so-called general purpose or foundation AI models. They mostly concern transparency rules, which apply to all general purpose AI models, and also some additional risk management measures in case of models that create systemic risk. I will try and explain what this systemic risk means in a moment. But that's the general idea, and this is what really the AI Act aims to cover in terms of scope, material scope. So the definition is quite a mouthful, I must say. Its AI system is defined as a machine-based system designed to operate with varying levels of autonomy, and that may exhibit adaptiveness after deployment, and that for explicit or implicit objectives infers from the input it receives how to generate outputs. And these outputs may be predictions, content, recommendations, decisions. And these outputs must be able of influencing physical or virtual environments. So it's quite broad. This is a way of trying and make sense of it. Now, since all of you are computer science researchers, you would have immediately, I believe, recognized the inspiration for this definition, which is, of course, from the classical Stewart and Russell textbook definition of what an AI agent does. in the sense of perceiving the environment and acting upon that perception. So the idea of the rational AI agent, it's all in here. Now, the various components of the definition are actually discussed somewhat in the recitals to the AI Act. But the origin of this definition, so if you want to make sense of the definition and where it originates from, it's actually the OECD. So the OECD published a definition some years ago on what an AI system is. And as you can see, it's the definition that we have in the AI Act pretty much follows the OECD definition. So whenever you wonder, okay, why did they decide to include this in the regulation, always go back to this original definition, which again, it might come as no surprise to you, was actually written by a team, but the head of this team was actually Stuart Russell. So again, quite obviously, the influence is visible. So when we say that the goals of an AI system can be explicit, so for example, when programmed directly into the system by a human developer, or they might be implicit. And when we say implicit, we mean through a set of rules, for example, defined by a human, or when the system is capable of learning new goals. Now, some examples of so-called implicit goals are, for instance, self-driving systems that are programmed to obey traffic rules. Well, they do not actually know the implicit goal, which is obviously to protect human life, but by stopping at a stop sign. Another example is a large language model like the GPT family of models, where the goals of the system are not explicitly programmed, but are actually acquired partly through a process of learning by imitation, what we know as learning by reinforcement through human feedback. And then examples of systems with implicit goals in the training data, where the final goal is not explicitly programmed, but again is included in the training data and in the architecture of the system that learns to mimic the data, such as, for instance, rewarding a large language model to generate a plausible response. There are many other aspects to these definitions, but in the interest of time, I will not spend much more time. Just keep in mind that the definition distinguishes between this build phase and the use phase, where, of course, obviously you have the outputs of the system which implicate the environment. Keep in mind that the structure of the definition that we have in the AI Act, and it comes from the OECD definition, is built on the idea that models are the heart of the brains, actually, of the system. So when we say an AI system, we usually mean a model that has interfaces connected to it, that has other components that actually make it a full system. So if GPT-4 is the model for ChatGPT, ChatGPT is actually the system. So in terms of regulatory objects, the system is ChatGPT, and the model is obviously GPT-4 or whatever version is the latest one. So that's the idea. If you want to get more, if you want to learn more about this definition, there is a very fine explanatory memorandum that I've linked here in this slide, and you would probably find interesting to go through, because it also gives some examples. Now, you may wonder, is it only machine learning that is actually in scope? And if you read carefully the definition, you would, of course, acknowledge that it's not just machine learning, but then recital 12 actually makes it quite clear that, okay, an AI system would obviously include, in the building of an AI system, you would obviously want to capture machine learning approaches, but also logic and knowledge-based approaches, so the traditional good old-fashioned AI that we know as encoding knowledge, symbolic representation, and so on. So the capacity of an AI system to infer actually must transcend basic processing by enabling learning, reasoning, and modeling. Now, our colleagues from the Algorithm Audit, which is an organization specializing in algorithmic audits, as the title says, they published recently a very interesting presentation about what sort of rule-based AI systems will actually be in scope. So, as you know, we could, for instance, create a decision tree manually based on domain expertise, or we could infer it, for instance, by statistical methods using optimization to actually come up with a decision tree. And that raises the question: okay, when would this fit into the definition? So the requirement of autonomy, for example, you see here a very rudimentary rule-based algorithm which evaluates a risk score. Clearly, what you see at line 13 here, the function that returns risk score would probably fit into the requirement of autonomy, because it autonomously computes the risk score for a person with age 19. So quite easily fits the autonomy requirement. But does it fit the inference requirement? So if the rules are, for example, created by humans, would that count as a system that is capable of inference? Now, I'm not going to explain to you, of all people, what a logic and knowledge-based approach to AI means. Just a few examples here. We have all studied discrete mathematics, so we know what this is about. But the main point that I'm trying to make here, and that the authors of this report did, is that essentially simple rule-based algorithms are not really a logic or knowledge-based system, because there is no knowledge-based or reasoning system, and as such they would not qualify as an AI system. Because otherwise we would end up with literally any algorithm capable of reasoning on the basis of human created rules, just qualifying it as an AI system, which would be ridiculous. So no, when we have manually created simple rule-based algorithms, and I agree with his assessment, in these cases we would not have an AI system in the sense of the Act. But if rules are learned, for example, through statistical methods, then yes, it would clearly be captured by the definition. And in this case, you need to go through an assessment of whether you have a high-risk system, whether you have a prohibited practice, and so on and so forth. So really measuring the impact, the effect of the system. Now, because I see that we've already we're almost up with time. I had a few more slides to share with you. One concerns data protection and one concerns copyright.
I think it's okay. You can cover it. We have a bit more time. Yeah, it's okay.
All right. Because I also want to leave some time for discussion. I think it will be interesting to hear your question. So just very briefly about data protection. I think that's important for you. People wonder, do AI systems actually, first question, training data sets, do we have personal data in the training data sets? Of course, we could have personal data in the data sets. That's quite obvious, which means that upon creating a data set, you need, so long as you're processing personal data, and the UK GDPR actually is quite consistent with the interpretation that we have in the EU GDPR, so they're interoperable in a way. You should always, upon compiling the training data sets, adhere to the requirements of these instruments. Now, what is the lawful basis? This is the biggest question here. So how do you actually justify that you are processing personal data on such a large scale? That's a very hard sell for regulators currently. I advise even clients of mine, well, you should, the best way is to use the ground for legitimate interest, where you have to justify that in compiling these data sets without asking for consent, obviously, you are actually not impinging too significantly upon the fundamental rights and freedoms of data subjects. And this balance is actually very, very challenging to make, especially in AI systems, in compiling data sets for AI systems, which are, we're talking about large-scale processing, obviously. I mean, you could literally scrape the entire web. And the fact that it's freely available does not mean that you can actually process it for these purposes. So you always need to justify why. But if there is one lawful basis for processing, because we have consent, we have contract, we have public task, and so on. If any of them is actually a relatively good fit, it's actually legitimate interest. So that's what most companies currently rely on. Trying consent is near impossible in an online environment where you have millions of users. You can't meaningfully get consent from any of them. So That wouldn't work. But then we have the question, okay, let's imagine we have a somewhat compliant data set that we have created. What happens afterwards? And to those of us who have ever built even a simple AI system or played with a large language models or fine-tune them, we know that in essence, models don't contain personal data as such. This is a very nice visual that you see here, which the Hamburg Data Protection Authority in Germany created to explain why large language models actually don't contain personal data. So through explaining the process of tokenization, what happens with once with the attention layers in the model, once we actually get the input and the output of a model, what happens so that actually there are no verbatim copies of personal data retained in the model. And this is not how actually the model works, by reproducing verbatim actual data, but rather patterns. So this is quite challenging for most data protection lawyers to figure out. And that's where it stops when it says that AI actually does not concern data protection, does not have data protection implications. Why? Because the instant you add the interface, and the model becomes a system, as I said, and once users start interacting with these systems, then all of data protection obligations actually of the deployer, which would also be a controller in this case, a data controller, kick in. So in this sense, you must justify on what grounds the model is processing personal data of the user, what happens to the output, how is it justified, and so on. So if there is one place where there are actually no personal data, and I'm completely aligned with this view of the authority, it's really the large language models, because many people have been almost desperately trying to argue that large language models retain personal data. I don't think so. I really don't think so. And the same, by the way, goes for copyright. Why do I say copyright? Because obviously that's the I like to say there are two legal frameworks that could bring down AI. One is definitely data protection. The other one is copyright law. So in copyright law, we have to be able to use a work, say literary work or a computer program or a database, you must have either a license by the rights holder, or you must really be able to rely on a statutory exception. And in this case, we have the exception called text and data mining, which in the EU is currently harmonized by a directive. And by text and data mining, I know it sounds old-fashioned, like probably 15 years ago, even more. But by text and data mining, we actually understand any analytical technique that is aimed at extracting, generating information, which includes patterns, trends, and correlations from text and other works. Now, this is limited only to the case of reproduction of the material. So you reproduce it to be able to extract information from it, and then you must delete the copy. So in this sense, if you compile a data set from publicly available but protected by copyright works, you could do that. You apply a data protection, a data mining algorithm to this data set. You extract whatever's necessary and whatever works for your task, and then you need to delete these copies, because you can only do this for so long as it is needed for the purpose of text and data mining. So this is allowed. This is allowed in the EU. What happens in the UK? In the UK, you might be familiar with the provision. You have something called Section 29A of the Copyright Designs and Patent Act, which actually allows you to do the same thing, but it is only limited to non-commercial research. So for you as researchers, you could actually benefit from that provision. And the requirement is that you limit these to the sole purpose of research for a non-commercial purpose. So if you are conducting these sort of activities or compiling data sets based on copyright protected works, you could rely on this exemption and not have to ask for a license from the rights holders. But again, only limited to non-commercial research. Now, let me give you a secret. I've been working with some UK clients, and what some of them do to sort of circumvent this provision is they create a non-profit association where they essentially carry out the text and data mining, and they produce a model, for example. And then because the model is as discussed previously, the model does not actually contain the copies of copyright protected material. What they do is they license this model to a commercial entity, and that's how you circumvent the provision. I'm not saying it's honest, intellectually honest or moral, but it is actually something that the law does not prohibit as such. So many companies in the UK currently, because there is no exemption for commercial purposes, try and circumvent this provision as I just described. And now here we will see a reference to a very interesting paper by some of my colleagues in Leuven, Thomas Margoni and Luca Chiroux, who actually took the time to analyze. This was specifically aimed at publishers. So you see here Springer, Helen and Francis Elsevier and others, what their current terms and conditions say about using text and data mining, because authors can, in principle, opt out of text and data mining. So you might write in your terms and conditions or apply machine-readable information metadata to your works to say, well, I'm not okay with you mining my content, and then you should respect this opt-out. And as you can see, right now, not that many, actually many of the publishers address the text and data mining provision. So whenever you think, okay, I'm going to mine this content, make sure to check whether all the rights holders have not opted out of text and data mining, because if they have, then unfortunately it's game over for you. And then on the right side, you can see some similar analysis for companies providing images like Shutterstock, like DeviantArt and Getty, Canva, and others. There is a whole big discussion about what it means to be able to access to have lawful access to the sources, because this is a requirement. So you may only conduct text and data mining on the basis of open access. I would say that for research it's quite generous. So obviously, based on open access policies, it counts as lawful access. If you're able to access the content through contractual arrangements between rights holders and research organizations, for example, on the basis of a subscription, this is lawful access. Other lawful means also covered. Any other lawful mean it can be covered. Now, regarding content that is freely available online, what do I mean by this? Obviously, libraries like LibCan or ZLibrary and so on, where you can actually freely access content, but it's not lawfully uploaded there. So can you access such content if it's freely available? I would say that for research, at least in EU law, it is plausibly defendable that you could also use these type of materials, but this only applies to the research exemption, because in EU law, commercial and non-commercial are actually two separate exemptions. And for non-commercial research exemption, you could actually probably rely even on freely available online material that is not necessarily lawfully uploaded, but for commercial purposes, certainly not. So if you know that the source of the material is actually unlawful, you should most probably not rely on it. So just to really sum up, the greatest challenges ahead. Copyright. First of all, figuring out the copyrightability criteria for outputs. This is still an unresolved matter. So when do you get copyright over a generated object? In essence, just really as a piece of advice, what you must do is make sure that you include as much human creative input as possible into the generated content, so that you can create a plausible ground for copyrightability, to be able to argue that, okay, I have actually put some effort into fine-tuning, refining this generated object. This is also what I advise many of my clients that rely on copyright, for instance, on generative AI, to try and defend copyright claims in their generated outputs. Defining the scope of text and data mining, because believe me, with this old-fashioned definition that we have from 15 years ago, it doesn't necessarily easily translate to the age of large language models, although I can confidently say that, yes, it does apply to generative AI and large language models, but we need to be certain of the scope, and this is still shifting sands a bit. Creating machine-readable standards for opt-outs, because I mentioned that you may, for example, put into the terms of use and conditions opt out saying, I don't want you to mine this content. But in fact, what in EU law, at least, the copyright directive says is that these must be machine readable. And there was a recent case in Germany where the court said, well, so long as it is expressed in natural language, machines at this stage can actually process natural language quite easily. So this should also count as machine readable. Now, to those of us with a scientific and engineering background, we know what machine readable means. It means structured data, and we know that that text expressed in natural language is not really structured data. We need something else to be able to claim that this is machine readable. But you can see that when courts actually do not quite understand what machine readable means in the technical sense, they are actually prone to saying, well, this also counts as machine readable. So now there is this debate as to whether just putting something into a license clause is machine readable or not. It's not to me, but at the end of the day, it does not matter what I say if the court takes a different view. And finally, this distinction between, specifically in machine learning, between generalization, memorization, overfitting, it's quite a mess. Courts and lawyers more generally don't get it. We wrote a very extensive paper with a colleague of mine that I dare to promote to you and advise, of course, to read and, of course, provide feedback. It's already in preprint, so it's publicly available on Zenodo. We called it Forget-Me-Not Memorization in Generative Sequence Models Trained on Open Source License Code, but it actually covers quite a bit more issues. And there we distinguish types of memorization where this is intended to the algorithm design, such as, for example, in support vector machines, where you need to memorize certain training points, all the way through unintended memorization that does not improve in accuracy, which is not actually needed for generalization, to unintended memorization that is necessary for generalization, where you could actually argue that some sort of memorization might actually be needed if we want the model to perform the way it is intended. So it's, like I said, a very lengthy paper, but I would suggest that you maybe check it out. And the same applies for data protection, figuring out the legal basis for data processing, again, understanding the differences between generalization, memorization, and overfitting, and of course, finding ways for data subjects to exercise their rights. And by ways, I mean technical means of how they can actually meaningfully exercise their data protection rights as data subjects. It's one thing to just put it in a policy. It's a completely different thing to find meaningful ways to do this and to help providers actually implement it. So I think it's a very vibrant community of researchers working around this subject. Finally, this report that was published by the AI Advisory Body to the UN, and there's actually quite a lot of, surprisingly, I must say, for the advisory bodies to the UN, I've never been impressed by the work they do. This one is an exception. I actually recommend that you check it out. It contains quite a bit of good ideas on how we should really, what we should really do for AI in terms of governance. And finally, something that Virginia Dignam has been preaching a lot recently, and I agree with her. We should also maybe start thinking of tools and other instruments that would help us figure out when AI is not the solution to the problem that we are aiming to solve. Because, if your only tool is a hammer, then every problem looks like a nail. I would like to believe that we can also find meaningful ways to understand when AI may not be the perfect solution to the problem we are seeking, and that's okay. So this is it. We did not have time to focus on the sandbox that we are running at Gate, but of course, this is maybe something for next time. We have established, as I said, this policy lab that we're running, and this is the team behind it. Thank you very much. Unfortunately, we don't have much time for questions, but I can stay a bit longer if you're all up for it and actually have a nice chat. Thank you.
Perfect. Thank you so much, Ivo. This was extremely insightful and particularly helpful for not only our research group members but also the master students who are here, because the content they studied, and I shared a transcript with you, which was with Guido, who was at Starling, and he's moved on to other university in Scotland. He talked about UI Act, but it was in the making at that point in time, year and a half ago. It was not a law by then. So to get an update on that is really, really useful. So there are some questions. Well, as I said, ask questions in the chat if you want, or just raise your hand using the raise hand functionality. So I have one question. I'll get started with that while waiting for the questions. I think it's it's from Adil Nabi. I'll try to sort of paraphrase your question, Adil, if it's okay, and let me know if I'm far away from
Sure, please.
what you intended. I think the question is asking if there is a framework or criteria to determine whether a specific activity, project, or work falls under the non-commercial research category as defined by the EU AI Act. And I think the related second question is, do you have to be working under the auspices of a regulator or educational institute to be counted as non-commercial research? Again, Adil, let me know if I have gone far away from what you intended to ask. Yeah.
No, thank you very much, Dhaval. That's all about. Yeah, thank you.
All right. So we don't actually have any guidance on that yet. We could draw on experience in the past. So we have some sort of guidance in the GDPR where we know that if you want to, for example, process data for the purposes of scientific research, you could actually do that, and you need to adopt some additional safeguards. But what counts as scientific research under the GDPR? Well, there we have the understanding that it covers not just university, academic in the strict sense type of organizations, but also industrial research. Now, that's why I hinted here that the AI Act is very specific when it says scientific research and development. But of course, one could plausibly, again, argue that the fact that research is done, for instance, at DeepMind, does it deprive it of its scientificity, so to say? I would say no. I mean, it's still research in the end, right? It doesn't have to be, doesn't say actually academic research and development. Even then you could still argue. So to me, you could plausibly defend that research done by private organizations that are engaged in research still counts as scientific research and development. The question is really that I would say probably the main criterion would be that we make sure that no profit is generated directly by this activity. Because the instant you start generating profit out of it, then you really would leave normally the domain of non-commercial. But yeah, unfortunately, we don't have much more guidance. I think the case is the same actually for the text and data mining exception that you have in UK law that I mentioned. I don't think there's much guidance on what counts as non-commercial there, but I think non-commercial is actually broader than scientific research and development, because a lot of things can be non-commercial even if they're not R&D.
Okay, thank you.
Thank you.
So I think the next is David. David is doing a PhD with us. He just started a PhD around looking at AI assurance. So David, go for it.
Hi, yeah, I thought it was really great talk. Thanks. I just had a bit of a question on maybe a bit of clarity on the boundaries around this sort of an enforcement around GDPR and the AI Act, and particularly the CE rating. So I was just thinking, if you're, say, a business, this is just one example, who's using, say, a model from the GPT store, then you've really got an end user who's using a model by a third-party developer built on OpenAI's platform. So, like, where does that responsibility fall there in terms of, is the third-party model CE rated and the GPT CE rated? Sort of, how does that work in terms of the boundaries there?
So you would actually, I mean, the obligation for the CE rating would actually lie with the one who is, to put it that way, putting the whole thing together. So whoever is marketing the system as such, regardless of what's going on in the background in terms of supply chain, if you are the one that, for example, is placing a trademark on the product. So let's say you have a company, you put the trademark in, the putting of a trademark on the AI system actually qualifies you as a provider, and as a provider, you are the one responsible to ensure the CE marking. Mm-hmm. Now, For models, specifically for models, actually you don't have an obligation to undergo CE marking. No model provider has to do that. Like I said, most models are actually out of scope. Only so-called general purpose AIs or foundation models are in scope, and only regarding some degree of transparency, and if they create a systemic risk, which is basically a very weird category. But imagine GPT-4, for example, that is used on a large scale by multiple organizations across the world, and that can actually propagate considerable issues down the supply for downstream recipients of the model. Then this would probably qualify as a model of systemic risk. Most, for example, smaller models would probably not count as such. But the CE marking lies with the obligation for CE rating lies with the provider, who is the one literally putting the whole thing together and putting it on the market.
Thanks. And just quickly, it was just on this sort of boundaries between GDPR and AI Act. I think you said that essentially the AI Act is covering really up to that sort of language model part, and then from a data protection point of view, I was talking about, and then the system itself would then move into GDPR from a sort of enforcement or reporting perspective. Was that right?
Exactly, that's right. So in many cases, so the provider of an AI system would be like the developer of an operating system. As such, they are not data controllers under the GDPR, but the one who is data controller would be the one integrating the deploying actually the AI system. So in the EU, in the AI Act, we have this category of deployers whom you would think of as users. So the organization that takes the decision, okay, we're going to deploy this AI system. The instant you take this decision, you become a controller under data protection law, and you must ensure that this system complies with the full set of requirements applicable to controllers.
Okay, thanks.
Okay, Bill, go for it.
This is probably totally off-piste, but I've an interest in technology in terms of safety critical systems, particularly railway signalling. With the concept of moving block, it's becoming more and more into a decision-making process where AI could be used. I'd be interested to understand what the legal aspects of an accident, an incident which caused death, as to who would be blamed for it.
So you mentioned, Bill, railway signaling system, right?
Yes.
All right.
I mean, in the past, they've been very safe, they've been fixed block, but the European system is moving towards what's termed moving block, where decisions will have to be made in terms of how fast a train should move, when it should stop. And that, from my perspective as a decision making, that's probably an area where AI could be used.
Absolutely. Actually, this is covered in the AI Act, in the so-called Annex 3, which qualifies some of the so-called high-risk AI systems. So whenever an AI system is a component, for example, of a safety-critical system, like railway signaling would fit in, like it would for air traffic control systems, and any sort of, including also in healthcare for medical devices and so on. So anything that comes with safety risk in mind would be covered, again, the new legislative framework with these 26 regulations that are covered by it. So in this case, the AI system would be a component of a safety critical system, and as such, it automatically qualifies as a high-risk AI system. So then you would have to undergo the conformity assessments, you would have to comply with the risk, you have to have a risk management, quality management system, data governance system, accuracy assessment, human oversight requirements, and so on. So all the requirements applicable to high-risk AI systems would kick in all these cases. So yeah, that's they thought about this actually, and this is the logic behind it. So long as it is a component, even applicable, the requirements applicable to this component would be the ones applicable for high-risk AI systems.
Thank you.
Okay, thank you for that. I'll probably ask one question considering the time, but yeah, if there are more questions from students, please do type them up. I think it's a very basic question about EU and UK. While EU is taking quite a proactive stance in terms of very comprehensive AI Act, which you covered really well in the detail. How does it compare to UK's approach to AI regulation in terms of scope, readiness, and enforcement? If you have any thoughts on that.
Right. Well, that's actually a lovely question. I might surprise you, but I should say I love your approach, guys. I mean, I think that was rushed legislation. It's poorly written. It doesn't even look like proper legislation. I mean, I saved you a lot of the nasty details of the AI Act, but there are so many unknowns yet. Even the definition is so convoluted that imagine this. I mean, you and I, we sort of speak the same language. We can understand what we mean when we say autonomy or adaptiveness or, rule-based and so on. But traditionally, because I also went to law school and I know how lawyers think, believe me, they don't have a clue about that. I recently gave a training on the Act, and I had to do, I think, almost 2 hours of explaining what the definition of AI system actually means. And these are people who are actually interested in the topic. Imagine a judge who has no clue what this is about, how they're going to rule in a case. I'm actually quite concerned. So my 2 cents, I would much rather have preferred that we took the UK approach of wait and see a bit, think of what the best strategy would be, where you need to intervene. Like I said, we have some good elements in the AI Act. Prohibited practices, which are common sense prohibitions anyway. Nobody wants social scoring in the democratic world, at least. Nobody wants emotion recognition and so on. The specific transparency risks that come for deep fake systems. Yes, absolutely. These are real, tangible risks that we know exist and we need to address. But the rest, I think it's too much perceived risk rather than actual risk that we can't even meaningfully measure, let alone govern through regulation. Same goes, by the way, for the copyright provisions that you have. In the UK, like I said, you have only text and data mining exception for research. There was an initiative of the Rishi Sunak's government, one of the last days of the government, I believe the last month at least, where they proposed that this exemption be extended to also cover commercial endeavors. And there was strong resistance, fierce resistance, in fact, by the creative industries. And then this was, they took it back. So this hasn't changed. But the wait and see and the more principles-based approach, addressing really the concerns that we fully understand, the risks that we fully understand and can measure, can quantify today, is to me the more sound approach. Because, I mean, like I said, I'm a researcher, but I'm also an advisor to companies. Companies come to me and they ask, oh, so what should we do? Like, should we be concerned how much it would cost? And to the question of how much it would cost, if you have a moment, I would just like to share with you a slide that I prepared some time ago about the cost of AI compliance with the AI Act. So there you go. I'm going to share screen again, just to give you an idea what I mean. So this is based, you should be able to see it. How much does AI compliance cost? For a typical AI project, this is based on the European Commission's AI Act Impact Assessment, and this is from 2021. So the figures have changed, I'd say, quite a bit. But let's imagine this is still the case. They assess that a typical project would cost about 170,000 euro, and they assess the cost of compliance at about 4 or 5% of that amount. So for providers of AI systems, this would be between 6,000 and 7,000. For deployers, so the ones using the AI systems, this will be between 5,000 and 8,000. And then verification costs, this is for the high-risk category where you would actually need to undergo conformity assessment, whether it's based on a third-party assessment or on the internal control system of the company. It would depend. In some cases, it would be between 3,000 and 7,500 on top of what you see above. And for SMEs, roughly the same figure. Now, I think this is I mean, it's not cheap by any means, especially for smaller companies, but I still think it's a rather optimistic figure. Why? Because this assessment it assumes that companies already have quality management system and risk management systems. Why do they assume that? Because the GDPR has been in force for how many? 6 years now. The thing is that most companies, especially the smaller ones, don't actually have this. So if they really want to comply with the Act, they would have to start building these risk management and quality management systems, and this is by no means cheap. So that's why I say that the idea that this is going to be cheap compliance, it's actually not real. And I don't want to end on a dark note, but I think that what's going to happen in the end is that we're going to deal with the prohibitive practices and maybe some of the high-risk practices, especially in regulated industries, like Bill's example of a railway signaling system. Obviously, railway operators are going to comply with this. But for the many smaller companies, some of them actually building systems that might present significant risks, they would just hope that, okay, I'm going to do what I can with the resources that I have, and pray that everything's going to be okay, even if the competent authority knocks on my door, which is less than ideal. So I would much rather prefer the UK approach, to be frank.
Thank you. I am aware of the time, but we'll take one last question. He's from
Right.
he always asks good questions, so we'll take his question as a last question. Deep, go for it.
Oh, this is a pressure you've added on me now. Okay, I actually had a two-sided question, and maybe you could just choose one of the sides. So one thing I wanted to ask was, you mentioned that researchers or people who are looking at academic research, they are kind of slightly in a better position because they are not looking at the compliance aspect like that. So I wanted to understand the motivations for that, maybe in a sentence or two, and then from there I wanted to also understand. So, because of the research that we are doing probably right now, some of the research will be using models, some of that will be using LLMs, whatever it is, and we will write it up. At some point, decision makers or stakeholders might pick that up and then might use that for designing interventions. So it's kind of bypassing a process of the Safety Act, whereas models that are being used in research are going to be used for decision making, but it's not under the same rigorous AI Act procedures. So I'm not in this field, so I'm not in the legal aspect, but I just wanted to get your perspectives on that.
So here's the catch. First of all, why was this created? It was created to make sure that researchers are happy people who can, have all the academic freedom that they need and be able to explore new avenues, and that they're not bound by the restrictions imposed by the Act, clearly. And then the catch is that, yes, indeed, research is exempted for the better part, so long as it meets the requirement of sole purpose of scientific research and development. But the instant somebody takes your model, for example, that is released on Hugging Face and makes a system out of it, they become providers. And then now these are the hidden incentives for researchers to actually consider the Act in what they're doing, because this would be a matter of due diligence on the part of the provider. I have chosen this particular model because it has these and these properties. And then it's your responsibility as a provider to make sure that you have conducted supply chain due diligence, that whatever resources you are using to build your system actually meet your requirements. So these are, I call them the hidden incentives for researchers to actually still consider the requirements of the Act, but they are not bound as such by its provision. So here's the catch. If you want to make sure that people are going to use your model, yes, you should think of how it can potentially, when integrated with other components in the system, of what its role is going to be like, and whether people would be confident enough to pick your model and not just someone else's model.
Right. Thank you, Ivo. I think we'll end the session here, but I'm ever so grateful, Ivo, for you to come and talk to us and sharing wealth of knowledge, which you did. But it was fantastic talk and fantastic Q&A.
Thanks a lot for the invite.
Thank you so much. I think this talk materialized is a great advertisement for LinkedIn that it works. So that's great. I'll get in touch with future opportunities and further collaboration. I think there was a few requests around sharing your slides, whatever you feel comfortable, or if you feel comfortable at all, do share it with me on via email if it is okay with you.
Absolutely. I just need to add a few links here and there to make sure that it's properly referenced.
Sure.
And once I'm done, I'm going to share with the slides with everyone. No worries.
Perfect. Thank you so much. Thanks a lot. Thanks, everyone.
Thanks a lot. Have a great rest of the day and take care, everyone.
Thank you very much, Ivo.
Thanks.
Thank you. Bye.
Take care. Bye-bye.
Thank you. Bye.